Judgment in the matter of MT Højgaard versus E.On Climate and Renewables UK Robin Rigg East Limited and another.
In 2009, the pylons in two recently constructed offshore wind farms started slipping down the piles set into the seabed onto which they had been sleeved with grouted connections. The question is who pays for the repairs, costing some £26.5 million, which had then to be undertaken. Is it the appellant wind farm owners, E.On, or the Respondent construction company, which I shall call MTH, which built and installed the pylons? That question depends on the contract between them and the technical requirements, the TR documents, in the tender documents, which were incorporated into the contract. The TR contained paragraph 3.2.2.2 little 1, which required MTH to prepare the detailed design of the foundations in accordance with a document known as J101. J101 was an international standard for the design of offshore wind turbines published by Det Norske Veritas, DNV, an independent classification and certification agency in Norway. J101 stated that its objectives included the provision of an internationally acceptable level of safety by defining minimum requirements for structures and structural components, as well as being a contractual reference document and a guideline. Section 9 of J101 dealt with the design and construction of grouted connections. It contemplated that the design might or might not include shear keys, that is, small surface protuberance, to increase the shear strength of the grouted connections. But it also set out equations from which MTH calculated that there was sufficient interface shear strength without shear keys, and that it was unnecessary, therefore, to include them. In fact, however, one component figure in the relevant equation was incorrect. The result was that the pylons as built and installed lacked sufficient shear strength at the connections where they rested on the seabed piles and so began to slip. MTH's case, as builders, is in essence that since the wind farm owners, E.On, specified that J101 should be used, the wind farm owners, E.On, are responsible for the unfortunate consequences of compliance with it. E.On's case is that this does not follow, because the contract went further. In particular, it contained provisions which they submit required MTH to go further than simply comply with J101. The TR stated inter alia that it was stressed that the requirements contained in this section and the environmental conditions given are the, in capitals, minimum requirements to be taken into account in the design, and that it was also to the responsibility of MTH to identify any areas where the works needed to be designed to any additional or more rigorous requirements or parameters. Still more importantly, the immediately ensuing paragraph after paragraph 3.2.2.2 little 1 stated that the design of the foundation shall ensure a lifetime of 20 years in every respect without planned replacement. The choice of structure, materials, corrosion protection, operation and inspection program shall be made accordingly. Another paragraph, 3b.5.1, was to like effect. A clause in those terms might amount to a guarantee that the foundations would last 20 years, or it might simply be a guarantee that their design could normally be expected to mean that they would last 20 years, but which here does not matter. What does matter is that on neither interpretation were the pylons as designed and installed compliant with such a criterion. The judge held accordingly that MTH were liable. The Court of Appeal set aside this judgment on the ground that the contract contained internal inconsistency and that the requirement to comply with J101 prevailed. The Supreme Court, in a judgment given by Lord Neuberger, with which all other members of the court agree, allows the appeal and restores the judge's conclusion. The clause of the paragraph immediately ensuing after 3.2.2.2 little 1 was clear on its face. The reference to J101 doesn't change this. While each contract must turn on its own terms, the courts will generally give full effect to a requirement that the product as produced complies with prescribed performance criteria, even if the customer or employer has specified or approved the design. In other words, generally speaking, a contractor takes the risk if he has agreed to work to a design which has the effect of making the product incapable of meeting the criteria which he has also undertaken to satisfy. Here, the TR were expressly also only a minimum standard, and it was contemplated that MTH might go, and that its responsibilities, if necessary, might go beyond the specified standard. That was the case under the relevant contractual provisions here. The appeal accordingly succeeds. We will adjourn.